We're very grateful to the co-moderators of this program who've assembled a really wonderful program that's cutting edge and is really so important if we are going to prepare our young lawyers to be practice ready. So many thanks to Delora Hughes of Wayne State University Law School and David Koelsch, University of Detroit Mercy School of Law, for serving as co-moderators and organizing what's going to be a really tremendously helpful and insightful program. So please join me in welcoming them, and they'll introduce our esteemed speakers. Thank you. So sorry, one other thing I just wanted to mention is there's a CLE attendance sheet, sign-up sheet for this session in the rear of the room. If you sign the sheet, the AALS will verify your attendance at this program for CLE purposes. Please refer to the sign-up sheet for more details. And also, we do value your feedback, and so we hope that you will take a moment and complete the session evaluation that you were handed when you walked into the room and leave it with the student at the door. And one other thing is, if anyone's interested, we do have some of our newsletters available for the balance section. Many thanks to Amy Bouchard for spearheading that. Our newsletter is called Equipoise, and she's done a beautiful job of summarizing the year's activities. So anyway, thanks, Delora.
Oh, thank you. Thanks, Julie. And I'll add one more announcement. Immediately following this program, the section on balance has a pedagogy program. It's scheduled from 5:15 to 6:30. It's Ready Law Students Lessons Learned from Recent Practice, and that's on the exhibition level Washington 1, and I would tell you where that is if I had absolutely any idea. So thank you again, thank you all for coming. This is a fabulous crowd. We appreciate you coming and taking interest in this topic. We are extremely pleased to have this wonderful set of speakers to present to you today. So just wanted to take a moment to very quickly introduce each of them to you, to give you a little bit about their background so you know where they're coming from. In order they will be speaking. First is Ms. Heather Bach. Get to the actual bio page. Dr. Bach is the Chief Professional Development Officer for Hogan Lovells US. She leads the learning function for associate and partner training and development. Her work experience includes designing programs and delivering training for professional service firms, as well as consulting with a variety of companies on HR strategy, organizational transformation, and culture change. She's the recipient of the HR Leadership Award of Greater Washington and the Chief Learning Officer Vanguard Award and Chief Learning Officer Collaboration Award. She is an author, several articles, authored a book on using a competency model to manage firm talent for the ABA. Please check that out. She holds a BS in Masters of Public Health and a PhD in Organizational Behavior from UNC Chapel Hill. Go Blue Devils. We also have Ms. Alli Gerkman. She became the first full-time director of Educating Tomorrow's Lawyers, which is a national initiative to align legal education with the needs of the evolving legal profession. That position began in May of 2013. She brought significant development professional experience to this initiative, having spent 5 prior years in continuing legal ed, first as a program attorney, and then as a program attorney and manager of online content for the Colorado Bar Association CLE. She's developed an online legal resource that was the recipient of the Association of Continuing Legal Ed's 2011 Award of Professional Excellence for use of technology in education. She's written, there we go, and presented nationally in continuing legal ed providers, bar executives, and lawyers. And prior to her work in this area, she was in private practice. She received her JD from DePaul University College of Law and her BA from James Madison College at Michigan State, where she majored in political theory and constitutional democracy. And last but certainly not least is Professor David Oppenheimer, who is a clinical professor of law and director of professional skills at Berkeley Law. Following his graduation from Harvard, he clerked for California Chief Justice Rose Byrd, then worked as a staff attorney for the California Department of Fair Employment and Housing, prosecuting discrimination cases, and was the founding director for the Bolt Hall Employment Discrimination Clinic. I'm sure most of you are familiar, lots of work, lots of publishing and presentations in journals and law schools around the country, co-author of the casebook Comparative Equality and Anti-Discrimination Law, and his book, co-authored book, Whitewashing Race, The Myth of a Colorblind Society, won the 2004 Benjamin Hooks Outstanding Book Award. He teaches Civ Pro, Leadership for Student Leaders, and Comparative Equality and Anti-Discrimination Law. We will begin with Ms. Heather Buck.
It? Oh, okay. Oh, got it. Okay. It's showing me the next slide. Terrific. Well, thanks so much. I'm delighted to be here. And I'm here really representing the law firm perspective. And just my sort of experience and research is based primarily on sort of larger law firms, but I think a lot of what kind of we've learned and what I'm sharing has relevance for medium and smaller size law firms, although I think there's certainly a great need for more empirical research sort of on all different levels of law firms and employers. But I guess first of all, the question is what are law firms looking for when they hire graduates from law schools? And no surprise, they're trying to all find that outstanding performer. And a lot of ways they try to kind of glean who those outstanding performers are looking at grades or the kind of ranks or involvement in activities. And sort of hopefully kind of they'll pick a good subset, and then even beyond that, the charge for law firms is then figuring out, well, how do we take them and make associates even more outstanding? Certainly knowledge of the law is an important part, but I think over the last several years there's been a recognition that knowing the law and the legal skills are certainly critical, but don't always predict who the most outstanding performers are. What I'm going to show is a little example of maybe a day in the life on a case team. And this is just a short sort of 4-minute video clip. And it's been used as a kind of as a discussion tool to show, well, what are the skills that actually come into play on a case team? Does leadership matter? Can team dynamics actually impact the outcome or the client's deliverable? How do you have difficult conversations with a peer? Is that important to know or learn? And should partners be able to coach? Is that a skill that that is important for people to know? I might need help getting out of here because I. So just to tee it up, we've got 5 players, a senior partner named Carmen, a junior partner named Mark, 2 associates, one who's new to the team.
Either junior partner or the other associate on the case work.
There you go. Oh, that's.
Okay, so the other one, partner, you can look at it.
Started at the beginning.
We require many things of you. One is to listen and fast forward.
I think we go back to the start.
And do not touch it.
Great.
Stepping away.
Shall I push play?
Upper right corner.
Oh, this.
There you go.
Got it.
And then, yes, and no more touching.
So you worked with Carmen before, right?
Yes, we worked together on a case about a year ago.
Yeah, how'd that work out?
We ended up getting summary judgment. It was a great result for the client, so I really enjoyed working with him.
Okay, terrific. Sean, how you doing?
Hey guys,
You know Ashley, right?
Sean?
we've met, yeah.
Excellent. Good weekend?
Yeah, it was a lot of fun. I mean, I was here obviously all day Saturday, but you got the memos got all the depot summaries done. We've got all the witness interviews, so.
Good. So here's the deal. We're ramping up to summary judgment phase, and we're going to bring Ashley onto the team to help us work through that.
Was this Carmen's idea?
Yeah, Carmen has worked with Ashley on a case before, and they won summary judgment, so he thought she could help us on this.
Great, so she's gonna help you with claim 1, and I'm gonna So keep going, or?
Yeah, well, here's how I'm going to divide it. I'm going to continue to maintain ownership over Claim 1, and then Claim 2, I want you guys to work on together. So you're going to have joint responsibility for the briefing, and then when it comes time for trial, we'll make it so everybody gets a chance.
Okay, I've got all the files and everything. I've did all the discovery, so I've got all the clips, I think. I've sent that to you. Did you take a look at any of that for Claim 2?
Right, can you get that stuff copied and send it over to Ashley so she can get up to speed on the case?
Surprise, she's on the case, taking my work. I guess Carmen's bringing her on. And I thought, all right, well, she's junior to me. Maybe she'd at least be able to do some research or something. No, splitting my case, splitting my claim, taking. I guess all the work I just did for discovery meant nothing. So.
I mean, I guess maybe he feels a little threatened by my presence on the team now. But he's just going to have to deal with it because this is what Carmen wants.
And then the marching orders for the brief, so just make sure you're on the same page. Now here's the wrinkle. The timing of this is going to be somewhat more aggressive than I thought at first. We need to have a draft. I need to see a draft in a month.
In a month?
Yeah.
That sounds good to me. I've been reviewing some of the case materials. I think I'm up to speed, especially with Claim 2. I think there's a lot of really interesting arguments that we can make there that we really haven't explored yet.
Yeah.
Oh, we'll make it happen.
Good, so my door is always open if you want to talk about anything. Otherwise, expect to see a draft in a month. Thanks, guys.
Yeah, thanks, Mark.
I delivered the news. And everybody reacted in about the way that I would have expected them to. Sean was probably disappointed. Tried to hide it a little bit. I don't think he was that successful. That's something he's going to have to learn to do, to maintain the posture of, got to put the case first.
I think Ashley's in a tough spot, but it's not one that many women in this firm have not been in before. She is on a brand new case team. She is the only woman on the case team. She was put on the team by a senior partner, and I don't believe the junior partner or the other associate on the case were advised that she was coming. So I think that there's that inherent tension there already. But it's nothing that Ashley can't handle. I mean, we've talked about this. I think Carmen is great to work for. I think he is a valuable resource in the firm, and she needs that relationship. So she's got to press through this and make it through this rough time and show them that she can do a great job, and I'm sure she'll survive it and be fine.
Hey, Ashley, what are you doing here so late tonight?
Oh, just working on the new case. I wanted to come and thank you for, giving me the opportunity to work on it. We're really looking forward to it.
Well, I think it's going to be a good opportunity, and it's a really important client. It's a really important time with this client. We have a new in-house counsel, and we definitely want to show him that we can get the job done.
Yeah. Do you think that there's a chance that it might go to trial? Mark was mentioning that earlier today.
It's hard to predict. I think there's probably a good chance that some of it goes to trial, but it would be great if we could knock out a big chunk of this case or better the whole thing.
Yeah, I agree. Summary judgment seems like it's going to be really key. And then one last thing I was going to ask you, do you have any advice or recommendation about how to handle Claim 2 going forward?
Well, Claim 2 maybe is derivative of Claim 1, maybe, but I think you got to focus on that claim and the independent elements of it in the brief, all right?
Okay, great.
Are you around on Friday?
Oh, I think so. Let me check my schedule and I can get back to you.
All right.
Okay, have a good night.
Good night.
See ya.
She's going to be trouble.
What?
That girl, Ashley. She's going to be trouble for the team,
Who are you?
Me. Don't you remember? I hired you for this firm.
You're dead.
Well, technically. Well, literally. But I exist, and spirit. And as a good guardian, I'm here to help the team.
Hey, I checked my schedule and I'm totally free on
Only
Friday
you can see
afternoon
me.
if you want to talk about the case. Are you okay?
Ashley, would you please tell Carmen that everything's going to be okay? I mean, he's getting kind of freaked out by yours truly. boogie boogie.
I'm okay. I'm just a little tired. In fact, I think I'm going to head out of here very soon. Terrific on Friday.
Okay, I'll see you then.
Okay, great.
Hey, Ashley, where you going? We got a lot to talk about. Hey, you're no fun. Shh.
I mean, this forestalls my development, right? I gotta get my writing competency. Summary judgment would have done that. I did a little bit of discovery, but with all the big dogs on the case, I barely got any scraps in discovery. And now I've got another person I've got to share all my work with.
Frankly, I don't have time to be at war with Sean. I mean, for me, it's really important to be a strong part of the team, please the client, please Carmen, and get the experience I need. I don't have time to be kind of dealing with Sean on the side.
Yeah, I see that as their responsibility. I don't know that I have the time to manage their relationship. They got to figure out how to work together well, and then give me the work product.
Things will be different when I run this place, but until then, you got to play the game and play the hand you're dealt.
So I think sort of probably you'll agree that there's a lot that goes into delivering sort of important things to a client, and because you're working with people, there's a lot of dynamics. And I think what a lot of law firms have found is it's important to help equip attorneys both with some of the legal skills, the traditional ones, like on the left, legal research, factual development, mastery of the law, writing, oral advocacy, negotiation, trial skills, kind of whatever it is, as well as some of the softer skills or professional skills like leadership, working with others, being able to sort of build good client relationships. And as a result of that, sort of being practice ready sort of is thought of as a little bit more holistic. This is just an example of one competency model, but it's not unlike a lot of others. This is sort of the Hogan-Lovells approach to kind of what are the important things that lawyers need to learn. And you'll see a lot of them are very similar. There's obviously knowledge of the law, being able to communicate that is critical, but you're working within an organization with people, you've got to work with teams, there's a lot of dynamics, whether it's managing your peers, managing up, leading and managing down. And the more that I guess we can equip people with the skills to manage the kind of the relationships and the situation as well as the law, the better off they'll be. So how do you do this? If you see kind of on the right-hand side, sort of leadership, you're not expected to read the small print, but the idea is really that some of these skills are really, I guess in old school was, leaders are made, or leaders made or born. And what we found is, yes, some people may have more of an aptitude to lead or more of an aptitude to be team players, but there are specific skills that can be taught and developed. And so thinking about these in a continuum of there's like a novice level of being a leader and then a more expert level of being a leader. And so wherever somebody sort of starts, wherever their baseline is, it's helpful to help move them up the continuum. So how are law firms doing this? This is just an example of how Hogan-Lovells tries to think about a lot of different strategies to help attorneys develop. Some of them are through training intensives. Those are sort of programs a little bit like if you're familiar with NEDA, where you come together, you practice. So whether you're practicing taking a deposition or you're practicing a group decision-making problem, you have an opportunity to try it out and get feedback and see how you're doing. There are other things, sort of the traditional, I call them sort of the talking head lunchtime programs where you might get updates to the law or learn about substantive law. Online learning is certainly a growth area. There are outside libraries like PLI or West Legal Ed that provide a lot of those things. And I think we're seeing a little bit more investment around mentoring and coaching and seeing how that can play a role, not just in sort of the senior person down to the junior person, but how valuable peer coaching can be. And what does that look like as a skill? How can you teach people to coach? And you can. And then practicum learning is, on this slide, is really just another name for tagging along. That watching somebody who's good at doing something, whether it's negotiate or conduct a deposition or lead a case team, is just a natural way for people to learn. In terms of making these professional skills a little bit more formal, a lot of firms, including Hogan Lovells, have actually been integrating formal programs where they bring attorneys together to actually learn some of these professional skills. So for example, at Hogan Lovells, new associates come in and they might learn some basics about, how do I litigate, or what are some basics around corporate and finance, but they also have a formal learning about their own style, whether it be through taking the MBTI and understanding how their work style it can impact a team, or looking at some other ways that sort of they can kind of influence, even though they're kind of the low man on the totem pole. Similarly, sort of it's the way that we've got it set up is the second, fourth, and sixth years are focused more on substantive training, so coming together to actually look at how to write a contract or negotiate a contract or take a deposition or argue a motion. And then the third and fifth years are dedicated more to these professional skills. So third-year associates learning how do I work in a team effectively, what is my leadership style, when is it more or less effective. As fifth years, learning a little bit more around what are the skills that it takes to actually communicate effectively and become a trusted advisor. And then as kind of more senior level, there's actually a formal program on how to prepare for partner. And a lot of that is based on how do you have a conversation with a client that's angry about their bill? Or how do you have a conversation with an associate that feels overworked and demoralized? So a lot of, again, sort of the kind of day in, day out sort of skills that are needed to actually get the legal work done are important. So trying to incorporate these a bit more. So I often get sort of asked more specifically, so how do you teach people to work in teams? What does that look like? And what kind of that can take a variety of different, I guess, lenses, but working with others, making decisions in a group, and leading others are really just learned the way we learn a lot of things, learning by doing. We often have simulations, which are basically day-long role plays. So you're thrown into a role for an entire day, and it's hard to fake behavior when you're kind of thrown into sort of playing the part of a partner or something else. And then action learning, where you learn something in the classroom and then you take it back and try to practice it on the job. An example of this is our kind of mid-level associate program. We use a leadership styles instrument in which the associates pick who they want to give them feedback. So they'll ask paralegals, they'll ask colleagues, they may ask administrative assistants to give feedback on their style. And then as part of the program, we kind of help them decipher, well, what does this mean about you? There's a lot of different styles. Some are better in different situations. So how can we kind of either expand the styles if you're using one too much, or understand when to use each one? We also use an interactive theater in which sort of professional actors will act out a leadership situation, and then the associates will give them coaching. So much like the video you just saw, if that were played out by actors, then kind of as sort of the audience, you'd have an opportunity to say, hey, Mark, maybe if you'd actually kind of introduced Ashley in a different way or talked to Sean before she came on board, that might have gone a bit smoother. So just sort of some opportunities for then the actors to replay a scene based on some best practices. And then there's sort of no substitute for individual coaching. So typically it's helpful for each person to get some one-on-one feedback on from both their peers as well as a coach who's been observing them during the program to tell them what they're doing well and what they might want to work on. Same with the program we have on client relationship skills. It's a kind of you're thrown into a part where you've got to meet with a client The client might be played by an actor or a partner, but the point is you're working in a team and you've got a series of meetings, and at the end of it, there's an opportunity to really debrief with your peers. How did you contribute to this? What worked, what didn't? And then from the client perspective, did they really feel like their problem was really understood? Did they feel heard? And did they feel like sort of it looked like the solution was going the right way? So a lot of these, it's probably no surprise. It's a little bit like sort of learning, I don't know if you ever sort of played golf or tried to improve your golf, that there's only so much you can learn by watching golfers on TV, or even if you kind of go out and sort of play 9 holes, that it helps if you actually have somebody maybe giving you some instructions saying, oh, here's why you're hooking your drive, or here's how to putt a little bit more precisely, and then going out to apply it. And that's a lot of, I think, what we've learned about instructional design and learning these skills, that sort of learning some of the basics and being able to have an opportunity to practice them and get feedback is some of the best ways to advance these skills. The other sort of, I guess, piece of research that I thought might be relevant for this panel is one that looked at who advances in large law firms. And this is actually just based on kind of an initial study that was done in one law firm, and trying to discriminate, well, you know, people come in, they're smart, they're hired at the same level, but some teams seem to progress at a faster rate than others, and some actually just seem like they're flourishing or they're happier. So are there things that sort of we can learn about either advancing, who advances or who flourishes, that might be helpful for everyone? And so after kind of doing some analysis at the firm level, looking at evaluations, looking at who made partner, using some of the social science tests that sort of tease out different variables. We did find a model, but we wanted to test it across firms. So we thought, well, maybe this is only unique to this one firm. The next part of this kind of phase 2 of the research was looking across AmLaw 200 firms. And we ended up with attorneys from over 75 of the AmLaw 200 firms participate. And we compared sort of people who are at the same level. Half of them had made partner after like about 10 years, and half of them hadn't. And we also asked them questions about, do you feel like you're really flourishing and growing? Do you feel like sort of you're in a sweet spot here? And what we found is there are sort of different categories. A lot of these are similar to the competencies that we saw earlier, and the competencies that we'll hear about in some of the other research on what makes effective lawyers. But some of them I think were slightly different, so I'll share a little bit of those findings. In terms of what predicted promotion to partner, there were sort of 3 key areas. One of them we sort of labeled master of fate. And this is really people who felt like they kind of proactively invested in their career, they looked for opportunities, and they felt like they were sort of in control of their environment. This whole idea of control is an interesting one because there's a construct called locus of control, and it's really a continuum. And at sort of one end, people who are low on locus of control feel like pawns sort of in life, and the people who are at the other extreme feel like they control everything. So it might be a little delusional, but the best place to be is a little bit to the, towards the feeling in control. And sort of I've seen kind of anecdotally, you see sort of associates come in and they kind of sit and wait for their career to happen to them. And they don't do well, quite honestly. So it wasn't surprising to find that this was an important variable of learning how do you take more control over your career, how do you sort of invest in it. We also, not surprisingly, saw that sort of people who made partner were highly networked. They like to tap into other people's expertise. They also like to tap into more informal mentors. And this kind of was an interesting finding because finding mentors along the way is a skill in and of itself. and finding people who can sort of guide you. And it doesn't always work when you're matched up with somebody formally. And they like to plan. They sort of had flexibility in that planning, but for the most part, they had a game plan. This is just a graph that showed people who had partners people who made partner were more likely to have informal mentors. And the specific, and people who didn't were more likely to have either no mentors or only 1 to 2. So those are the kind of the graphs on the right there. So again, just sort of when we think about sort of professional skills, building relationships, not surprisingly, is important to be effective. The other area that was interesting is kind of we hear a lot about, oh, there's so many miserable people working in law firms, and thinking, well, surely somebody's happy and flourishing, and what is it that makes them happy about what they're doing and feel like they're flourishing? And are these things that maybe we could help or teach others who want to have a career in a large law firm? We found actually quite a lot of things. These people that said they were flourishing, they felt like they liked being the best, so they had a strong kind of drive for excellence. They said they enjoyed overcoming challenges. If you ask them, they kind of like to take ownership of problems. They were also nimble, what we call nimble thinkers. So they would try to be resourceful, and if sort of things came up that they didn't know how to handle, or they tried to kind of react to things. And again, it kind of gives a little bit of the image of a good sports player, that they kind of might have a strategy of how they're going to sort of, if they're going to volley or run to the net, but they're on their toes and they're ready to switch gears if need be. And so these people were nimble thinkers. The people who flourished also liked relationships. They liked to make them work. They liked to be valuable and help others. They talked about having kind of a good face to the world, so even if they felt a little bit underconfident, they'd kind of put on a good face and show more confidence. They said they enjoyed working in teams and that they liked making friends at work. These people also seemed to be more comfortable handling conflict directly. They liked growing and learning. Most of them had rated themselves as more optimistic, saw the upsides of situations, and they also had more autonomy. The autonomy kind of is an interesting one because it actually relates to this next piece of flourishing. We were interested in some research in the public health arena that found that the people, research that was done on actually government workers, and found that those that had suffered the least from minor ailments, like colds and headaches, were also the ones that said they were least micromanaged. And so we were interested in finding out, does that hold true in a law firm? Because there can be a lot of micromanaging that goes on in a law firm. And we found out actually a lot of things, that people who, again, this is self-report, who self-reported that they had less kind of colds and minor ailments, also had a stronger self-image. They had clear boundaries. They weren't afraid to say no, which is important when you're getting a lot of work thrown at you, figuring out what you can handle. They didn't care as much if people all thought they were smart, so they kind of gives a sense of self-esteem without getting a lot of outside feedback. Again, this idea of being master of their fate, managing conflict, liking to grow and develop, being optimistic, and then obviously this idea of autonomy. So some of these, they may sound like, well, gosh, isn't that just personality? Sort of, you're lucky if you were born that way. And yes, you are, but there are also a lot of, I guess, research that's showing that even if you are sort of maybe more of a pessimistic person, again, there are ways to sort of kind of rethink or reframe things. This is used a lot in the resilience research to help you move you along the meter towards a little bit more optimism. And so I think sort of when we think about how do we develop high performers, whether we're at the law school level or in the law firm or employer level, that thinking about mindset and philosophy, that attorneys are bringing to the table, as well as these key skills and behaviors, both the legal and professional skills, could help set people up for more success and help them flourish. With that, I will turn over to Alli.
Okay, thanks for having me. I don't always get to come to AALS meetings because I'm not actually employed by a law school, though as the name of this initiative, Educating Tomorrow's Lawyers, might imply, law school and legal educator partnerships are pretty critical to the work that we do. We are actually based at the Institute for the Advancement of the American Legal System, which is a national research center that is committed to continuous improvement in the legal system. We work through a variety of initiatives, including this one. And we're based at the University of Denver, but like I said, it's the broader university. So we are not officially a member of AALS, but thank you for having me here. I'm going to talk a bit about a couple of projects we're working on because they're directly related to this topic. One is about identifying what foundations really are critical for entry-level lawyers. And the other is actually the evaluation of a program that is trying to work to educate lawyers toward those outcomes. So I was asked to speak also about some of the innovative work that's taking place in law schools around the country, which makes a lot of sense given what I do. So I wanted to actually start here with a confession, which is that I hate this word. It came up a lot this morning in a panel on innovation and legal education. It's not that I actually hate what's behind innovation, right? This is important work that's being done. But the problem is, too often, what we're doing isn't actually being measured. There's not necessarily an end goal in mind, and we're not measuring whether we're actually getting there. And so I would pose the question as we walk through this, if innovation isn't measured, does it actually matter? But the reason it makes sense for me to talk about innovation, and the reason it's a confession that I hate the word, is because I use it all the time. Because we do work with a number of law schools and legal educators who are doing really innovative things. We have a consortium of law schools around the country, 34 and growing, and the dots represent where they are. And we, since the beginning of Educating Tomorrow's Lawyers, one of the things we've really strived to do is bring them together so that they can collaborate, teach each other, learn from each other, and help each other grow the various programs that they're working on around the country. That said, that's where we launched and that's where we started, and we have these strong roots then because of that support that we've tried to offer. But since we launched, there's been a real shift in the amount and the tenor of the conversation around legal education. So you have media, you have the profession saying things like law school's too expensive, too many grads are unemployed, and most importantly here today, and for my initiative, law school isn't preparing lawyers to be, well, lawyers. So let's take a look at that piece for a bit. We're hearing things like this. We don't want to see the names of first or second year associates on our bills. This is, of course, a client. There are virtually no openings. They can't hang a shingle and start on their own. Many of them are now asking their schools, why didn't you teach me to practice law? And this one, which is long but important, so I do include it in here, and this is actually from the California State Bar Task Force report. We do not delude ourselves that it is possible to bring about a system of training in which new lawyers would somehow emerge from law school fully formed and in possession of all the judgment and maturity that we know comes only from experience. What we do expect, however, is that new lawyers enter the profession oriented to the actual experience of practice and the values of ethics and professionalism, so that when they begin to absorb that experience as practicing lawyers, they all have a proper foundation for growth. These are important comments to hear from the profession as legal educators think about how to proceed. The challenge is that often when you go back to the lawyers, the very lawyers who are making these comments and say, okay, what is it that we're aiming for? You get an answer that's something like this, which makes it hard to really do anything. We launched earlier this year a project called Foundations for Practice, which is a multi-year project. The objectives of this are first to identify the foundations that entry-level lawyers need to launch a successful career. Second, to develop measurable models of legal education that support those foundations. And third, and importantly, to align market needs with hiring practices. It's a big project. So what I'm really going to talk to you about today is the first part, but I'll show you the steps here. I'm going to talk to you about the national survey. That's where we are right now, and I think that's what will be of most interest to this group. But after the survey, and the national survey is being distributed through state bars in the hopes that we'll get as broad of distribution as possible, and we'll get to hear from firms beyond just big law. We'll get to hear from small firms, from solo lawyers, from people working in government, from people working in legal services, and we'll be able to evaluate the results based on practice setting, based on size of organization, based on all of these things. So I'll talk to you more about that in a moment, though. We'll then do a series of focus groups to make more sense of the data to the extent we need to, and we will compile those results and bring them to a convening of our law school consortium this fall, in September, I believe it will be, along with some members of the profession to make sure that we can have a productive conversation that takes a look at the results and sets out some recommendations for moving forward. We'll report on those results, the recommendations, and then we'll move forward into the next phase of the project, which really will be to work with people like you and members of the profession who are interested to identify the models that will actually work toward those outcomes, and to identify existing models, because, by the way, I suspect there are a lot of existing models that do work toward that. And I think that understanding what those outcomes are and understanding how they fit in with existing models will help law schools and legal educators better demonstrate the value that they really are offering to law students. So. And then, of course, we do want to get back to this piece about working with employers to understand where the disconnect is in terms of what they're saying they want when they're looking to hire and the candidates that they actually do hire. So just to give you a sense of this, as I mentioned, we have a consortium of law schools because we like to work with a number of partners. We also pulled together a group of members of the profession for this particular project, including folks who represent all sizes of firms, all types of organizations, and then also including people who represent larger organizations that represent lawyers around the country, including the National Conference of Bar Presidents, National Association of Bar Executives, the American Bar Association, and the National Conference of Bar Examiners. So now I'm going to talk about the survey. The way we pulled this together is we actually tapped into existing research. We tapped into Schultz-Zedek, of course. We tapped into work by Neil Hamilton at St. Thomas. We read literature by Bill Henderson. There are a number of people who are talking about this, a number of organizations who've done work in this area. We started there. Then we reached out to the profession to identify some other potential foundations. We call them foundations because competencies is a bit limiting. Foundations encompasses competency, skills, characteristics, traits, and so forth. And we came up with this great list that was like 250 long and probably would have taken 10 hours for lawyers to actually take. which was not going to be effective. So we did cull it down a bit to the extent we could, and then we vetted it again through those researchers. I'm very grateful to the researchers who did take a look at it, and then also through members of the profession, bar associations, specialty bars across the board to really thoroughly vet the survey before we put it in distribution, which is where it is now, and I'll get to that in a moment. But I wanted to show you, this breaks down the different sections. Items, that means there are 12 items in legal thinking and application. There are 24 items in qualities and talents and so forth. This is the section stress and crisis management. I pulled a couple of sections that I thought this group in particular would be interested in. And this gives you the scale as well. So you see how we actually laid it out for folks. They indicate whether the item is necessary in the short term, must be acquired over time, advantageous but not necessary, and not relevant. And this, like I said, is the stress and crisis management with coping with stress in a healthy manner and so forth. Another section that I thought this group might be interested in is the passion and ambition section, which goes into the commitment to justice, passion for public service, those types of things. Notably, the qualities and talents section is actually the longest section of the survey. This is probably, it's hard to say, but we suspect it might end up being a pretty important section. When we were pulling together the survey, especially from the profession, these are the things they were talking about. They weren't saying, you know, I really feel like lawyers are graduating and they're not able to engage in legal reasoning. That wasn't what we were hearing from employers. They were bringing up these. In one of our initial pilot groups, as we were testing this, someone said, the most important thing that I need from a new associate is that they can take something and run with it and finish it. And when you think about the things that are involved in being able to do that, those are all the things that show up on here: resourcefulness, diligence, confidence. So this will be an interesting section to watch. We also include in it some questions at the end that relate to hiring. So how helpful are each of the following in determining whether a candidate for employment has the qualities that you have identified above as important? And then we list all of the, these are not news to you, the class ranking, law journal experience, and so forth. We also list a number of experience-based items like actual experience, experiential education, clinics, externships, previous work experience, that type of thing, to get a feel for, once they've gone through this and said what they feel is important, what are the hiring indicators that they think are useful in finding those characteristics in people. And we will dive, what we'll do then, what I suspect we'll end up doing with the results is that will be a big topic of the focus group, particularly if there's any disconnect that seems to be there. So just to give you some sense of where things are, these are the states we're already talking with and where things are either already distributed or looking pretty good for distribution. These are the states that have already distributed or are about to hit the send button, so if you're in one of these, you'll be getting it yourself soon. We really are working to get it out in as many states as possible, and so far the response from state bars has been really positive. It's been actually a really interesting side piece of this project in that the state bars, I think, are just as interested in this information as law schools and legal educators are, because they're thinking about their new grads and the skills that they're missing and how to bridge that as well. And they're thinking about ways to collaborate with law schools too. So that's been a really fun piece of this particular project. So I'm going to talk then about a program that is already in place that uses, they're obviously not using results of our survey, and they're not using Schultz and Zedek. They use McCrate to identify some of the outcomes that lawyers should have or new lawyers should have. And we did a program evaluation of this program. It is the Daniel Webster Scholar Honors Program at the University of New Hampshire. We are about to release this report in the next couple of weeks. I wish we were releasing it today, but that was not to be. But I am going to talk to you about some of the interesting aspects of this. So the program itself is the result of a collaborative effort between the bench and bar in New Hampshire and the school there. New Hampshire is, of course, a small state. It's a small law school, and the Daniel Webster Scholar Honors Program is a small program, which gave them a perfect opportunity to try something really, really new and different, and that has been quite successful, something that's been quite successful. So basically what they do is they replace a 2-day bar exam with a 2-year assessment, where bar examiners are embedded in the program and they evaluate at a few points during the 2 years the totality of the performance of the student, looking at portfolio, reviewing videos of performance, that type of thing. It's a set curriculum. It's highly experiential. And there is, as I'll talk about in a moment, a significant amount of assessment that's built right into it. So our analysis of the program focused on two major sources of information. One was standardized client interview assessments of third-year Daniel Webster scholars and New Hampshire lawyers who had been licensed to practice for up to 2 years. And the other piece that we were able to take a look at were focus groups that were conducted in 2013 in New Hampshire with members of the bar and students, faculty, administrators at the school. These were conducted by Bill Sullivan and Lloyd Bond, who you may know as authors of the Carnegie Report. So our key findings are these about the program. When evaluated based on standardized client interviews, and I'll talk a little bit more about those in just a moment, students in the program outperformed lawyers who had been admitted to practice within the last 2 years. And the only significant predictor of standardized client interview performance was whether or not the interviewer participated in the program. Neither LSAT, to the extent we had other information to compare, neither LSAT scores nor class rank was significantly predictive of interview performance. So the standardized client interview, if you are not familiar with it, is basically, it uses professional actors who are trained to act as clients and to evaluate the interviewer on standardized criteria. So in this particular case, they're evaluated as an overall assessment, and then they're also evaluated for how much information they were able to obtain. So for overall assessment, you see up here, these are a lot of the things that would come up in the qualities and talents section of the survey I mentioned, or some communication skills. The greeting and introduction was appropriate. I felt like the lawyer listened. The lawyer accurately summarized my situation. If I had a new legal problem, I would come back. And so this is the way the DWS students performed as compared to the non-DWS lawyers who had been licensed for up to 2 years. And you can see there that they did, in fact, outperform them. The other piece of the standardized client assessment is the information learned. So the actor has these facts, and it is the job of the student or the lawyer, for the purposes of the study, to extract those facts. And based on their interviewing skills and that type of thing, and their ability to understand what to ask. And here we see again the DWS students outperforming the non-DWS lawyers fairly handily. So I'm not going to talk too much about all of the specific comments from the focus groups. I will say again, the report's coming out soon, and you will certainly be able to read quite a bit more there. But some of the comments that just came out again and again across the groups, including members who were of the profession who worked with the DWS alums, is that they're ahead of other grads, that they're able to hit the ground running, and then importantly for purposes of our report and thinking about recommendations, they talked a lot about how formative assessment in a practice context was really key to helping students develop their skills over the course of the 2 years, and that they also talked about how significant of an undertaking this is because of the amount of collaboration that takes place with the profession. Again, because in this particular case, this was brought forth by the profession. It was brought to the law schools as a possible. They started talking about it, but it was a Supreme Court justice who really wanted to spearhead this and push this forward. And then they obviously need the profession to be engaged throughout as they're teaching them and working with them and evaluating them and all of that. So it's a big undertaking in that way. On the assessment piece, I did just want to note, so these students are rigorously assessed in this kind of cyclical, ongoing fashion. So they're being assessed all the time by professors, by lawyers, by judges, by the bar examiners, by each other, and by themselves. Reflective assessment is a major component of this program, so that just as they're being evaluated and assessed by others, they're evaluating themselves so that they'll be able to take those skills when they leave law school and continue to develop professionally over the course of their careers. So in brief, the major recommendations we took from it are these. This is not to suggest that we don't think states that are interested in coming up with a 2-year bar practicum should try it. It's just that what we wanted to really do was unbundle the key factors of success of the program so that school or even educators in their own individual courses could take something and learn from it. So that said, we think it can be applied in an individual course, the lessons that are learned in this particular program, or in a school, and perhaps you could actually look at working with the profession, working with the court to come up with something as robust and comprehensive as this program has. So we suggest to provide a learning environment with formative and reflective assessment in a practice-based context, and to build collaborations between the academy and the profession. And again, so you heard me talk a bit about that with the other project. The profession is really engaged on some of this right now. And I think to some extent that can be alarming if they're setting new regulations and things like that. It can pose a challenge. On the other hand, it poses a real opportunity to tap into the expertise they might have and try to build something together. So we do make that recommendation to see where there may be opportunities for collaboration there. There are other programs that are in place that are being assessed, and I actually just highlight here another major program assessment that's taking place. This is of Northeastern, and Bill Henderson is leading the research component of that. But I also wanted to point out how you can also assess things at a course-based level too, and Neil Hamilton, who I've mentioned a couple of times, has a roadmap program that he uses in his professional development or professional, forgetting the name of the course, but it's at the beginning. I see Jerry standing there. He knows the name of it. Professional responsibility, thank you. And so he's been testing what he's doing. I was thinking of this when Heather was talking, because he is helping students basically take more control, be masters of fate, as Heather talked about, and begin to define their own career paths and their own education paths and all of that. And he's evaluating where they are when they come into the course, and he's evaluating where they are when they leave. And so this is an example of how you can assess at a course-based level, and with DWS or Northeastern at more of a program-based level. And the reason I point that out is because I think to make innovation matter, that evaluation piece is really what needs to be done. Along those lines, I would just say to track data when you start something, even if you aren't sure necessarily what you want to track, start to track it, but more importantly, use it. And then finally, so critical to the work we do at Educating Tomorrow's Lawyers is to share it. Because the more that all of you share what you're doing and share what you're learning and share both your successes and your failures with others, the more the institution as a whole will move forward. So, thank you.
Now, can I? Yeah. Good afternoon. Well, so be it. Doesn't matter. Oh, okay. It's my privilege to talk with you about some research that's been done and continues to be done at Berkeley by Marge Schultz, a law professor for many years at Berkeley, now emeritus, whose career has been dedicated to studying the legal profession, and Shelley Zedek, a professor of psychology at Berkeley, also now emeritus, whose research for his entire career has been dedicated to how do we test in order to predict behavior. And they came together and did some research, and I'm hoping that when you leave this room in about half an hour, that you will take with you three things. One, I'm hoping you will take with you the belief, or at least the suspicion, that this research is important in terms of its potential impact on how we admit law students to law school. Two, I'm hoping that you will take with you the belief, or again, at least the suspicion, that this research is important in terms of what we teach and how we teach it, our curriculum. And three, we're going to do an exercise. I know you've been sitting a long time, and so we're going to make you get up for a minute. I'm going to make you talk with other people and do an exercise, and I'm hoping that you will find it sufficiently provocative that you will leave the room saying, gee, I want to think some more about what we began talking about with that exercise. So those are my three goals for the next 20 or so minutes. In 1996, Marge Schultz and Shelley Zedek started working on this research project, and they did so in large part out of dissatisfaction with the LSAT and the fact that every law school in the United States relied heavily on the LSAT to decide who should be admitted to law school and therefore who should be admitted to the legal profession, and that they weren't really sure that the LSAT was testing all of the things that we should be testing in order to determine who's likely to be an effective lawyer. So they decided to return to ground zero and ask the question, what makes an effective lawyer an effective lawyer? What are the factors that lead to effectiveness for members of the legal profession? And they met with hundreds of lawyers and judges and clients who hired lawyers, although most of them were also lawyers. They were in-house counsel. Most of them in the first round, graduates of Berkeley Law. And they went through extensive focus group discussions with them. And out of those discussions, they developed 26 factors that many of you have seen, and I'm going to pass them around in a few minutes. Those 26 effectiveness factors of effective lawyering were sort of the first stage in the Schultz-Zedek work, and if they had done nothing else, Dayenu, does that word make sense to at least some of you? It would have been enough. If they'd done only that, it would have been important, I think, to us, because what they identified, partly what they identified, was completely familiar and predictable. Analytical reasoning, good speaking ability, good writing ability, problem solving, that these were among the factors that lawyers and clients felt were important in identifying effectiveness in other lawyers. And then there were some that at least some people might have found surprising. Listening, the ability to manage the work of others, organizational skills, relationship building, integrity, good, passion, and my favorite on the list, which they've listed as, did I say compassion or did I say passion? I said passion, good, because the last one is compassion. That the ability to see the world from the point of view of others. Compassion, empathy. That it turns out that empathy and compassion are really important in lawyers. If they'd gone no further, it would still be worthwhile for us to take a few minutes to look at this list, but that was only the start. They then asked the question, for each of these 26 factors, can we define what excellence looks like, what good looks like, what average looks like, what fair looks like, what poor looks like? And they went back and they met with several new focus groups of lawyers and judges. And they ultimately came up with 800 descriptions that covered the 26 factors with great specificity in terms of, what does it look like when somebody is a good listener, when a lawyer is a good listener? And they had several examples of excellence in listening and several examples of good listening and fair listening. And out of those 800 descriptions, they worked with those 800 descriptions with 2,000 Berkeley law graduates over a period of several years. And they used those meetings with those graduates, working with those descriptions to create a scale so that for any particular effectiveness factor, you could look at what somebody had done. You could look retrospectively at a lawyer's work and say, as to that effectiveness factor, that was a 3, that was a 1, that was a 5, and to rank people in that way. Dayenu again. If they had stopped there, that would have been enough that we would have had something really valuable that we could use in evaluating our own work and the work of others. But they didn't stop, and here's where I feel it gets most important, and that speaks in part to my interest in issues of racial inequality. Because they then went on to ask, can we predict performance in these 26 effectiveness factors among people who have not yet started practicing law? And they looked at young lawyers. They looked at young lawyers who had just started practicing, and they looked at over 1,000 of them. And for each of them, they put them through a battery of psychological tests, some of which already existed, and some of which they created. They created several new situational judgment tests. And they had each of these young lawyers identify 2 peers and 2 supervisors who could evaluate those lawyers' work. And as a result, they tossed out some of the tests, they changed others, and they came up with a battery of tests that can be administered in about 1 hour through a multiple choice examination that predicts with, I'm not a scientist. What's the term? Thank you. With statistical significance. That's not so hard, is it? That predicts the 26 effectiveness factors. That is to say, they came up with a test that could be used as a supplement to the LSAT that gave you a very different kind of report. And here's the kicker. Here's why we should all be paying attention. It had absolutely no racial adverse impact. I want you to sit with that for a minute. The LSAT is screening out huge numbers of minority applicants. And according to this research, it's doing so completely unnecessarily. We know from experience, we know from other research that's been done, that minority lawyers perform just as well as white lawyers across any scale that anyone's come up with. Now we also know that huge numbers of minority lawyers are being screened out by the LSAT when there are alternative tests available that will have no racial adverse impact and that will be doing a very good job of predicting future lawyer effectiveness. Now we'll pass out the list, because I want you to do an exercise with me with the list. And volunteers are coming through the audience as we speak. How are we doing on time?
So since our crowd is obviously compassionate, passionate, and overachieving, there's...
And collaborative.
And collaborative. There's more of you than there are handouts. So in the spirit of collaboration, please share with your neighbor.
Yeah. We thought there'd be about 40 or 50 people here, and we're delighted, of course, that there are so many more. So first, as you look at the list, again, some of the effectiveness factors that you see here, nothing surprising about them: analysis and reasoning, problem solving, researching the law, writing, speaking. Others may be more surprising. Creativity and innovation is important. Listening is important. Strategic planning. But ability to see the world through the eyes of others. That combination of empathy and compassion. What I'd like you to do is to get together with 2 other people. So I want you to get into groups of 3. And I would like you to discuss for the next 5 minutes how in my teaching, how many of you teach in doctrinal areas? Okay. How many of you teach skills? Good. Okay. Ask the question, discuss the question, how in my teaching can I teach my students the ability to see the world through the eyes of others? How can I teach empathy? Okay? So it's all yours for 5 minutes, and then we'll gather back together as a group.
So I just wanted to quickly share with all of you that if you are interested in receiving at least most of the materials today, the PowerPoint and the handout, we're happy to share that with you. If you'll send me an email, my name is Delora Hughes. I'm at Wayne State Law. The email is D, as in Delora, or Duck, if you will. Hughes, Hughes, at wayne.edu. And so it's WAYNE. And I'm happy, please, it's okay to kill my inbox, but we'll get those materials out to you guys. Thank you. No, unfortunately not. Sorry. That's why I said most of the material.
Sure. So, volunteers, what'd you come up with? How are we going to teach this to our students? Oh, come on. I'll start calling on people. I'm going to call on Sue Shack. Oh, there we go. Hi.
Hi, Marjorie Silver from Turo, and many of the people in this audience probably heard me say this is the teaching method section, but I think it's a perfect example of something I haven't done in the past, plan to do in the future, and I got it from Nathalie Martin's brand new article in University of Arkansas Law Review, where she has her students pick a party from whatever doctrinal case they've read and write a journal entry from the perspective of that person, in the voice of that person.
Yeah, that's great. That's great. Yeah, you know, you can use a variation on that to teach both this communication, both this personal skill, this what some people call a soft skill, although I don't like that term, and to teach some doctrine at the same time by asking students to write some correspondence back and forth. Like, you know, you're Neff's lawyer in civil procedure. Write Neff a letter explaining what the Supreme Court just did. You know, followed by, you're Neff. Write back and tell your lawyer how that felt. Others? Sue.
Well, we talked about, you know, the hypotheticals, which we already do in our classes, but so instead of the typical model of student or of lawyer-client, to add a third person, an observer to that, so the observer can be this like listener and translate back, and then also having them just switch roles, so even after you debrief it and you feel like you've gotten all you can out of it, then having them switch the roles and play it out and see, you know, how much deeper you can go with it was another idea we came up with.
Yeah, and you know, using teams generally creates all these opportunities for students to teach each other. And one of the things it creates opportunities to do is to teach each other about how it felt to play the various roles that they played. Another thing it does, by the way, in teaching doctrine, again, in civil procedure, I use clickers and in the classroom, and if I find that I'm on a doctrinal question and there's a fair amount of confusion, and I've given them a multiple choice type question and they're split 3 different ways pretty evenly, I ask them to discuss it for a few minutes in small groups, and then I test them again without having said anything more, and they've shifted dramatically in most cases toward the correct answer. And it's because once they start talking about it and listening to each other, they figure it out together, even if they hadn't understood it when they came into the classroom. It's not because of anything I said, it's because of what they taught each other. And that in turn encourages them to do more teaching of each other as they see very graphically on the board that it worked. Yeah.
Actually have a question about the simulations do this all the time, and the program of negotiation at Harvard Law School has a role reversal exercise. It's quite good, but I'd be curious to know if anyone has guidance on the following situation. The problem that clients have, and have experienced this as a patient in getting a diagnosis, is that your cognitive ability now shrinks. When you get a threatening diagnosis, your ability to respond and understand goes away. And I'm very interested in how people deal with the problem of how to educate students to deal with clients who in fact can't understand what they're telling them because of the cognitive difficulties of the emotional strain. And the problem I have with the client interviews that you've just described is that people may be an actor, and an actor isn't under stress. They're just trying to see whether somebody gets the information out. But the response of how you deal with people who really can't understand what you're saying is something I'd be interested to know people's response to.
Good question. Responses? Thoughts, suggestions? Yes?
Gary Tamsett from the ANU in Canberra, Australia. We do quite a lot of simulation work, including the standardized client that Alli discussed earlier. And we can train actors and also other non-lawyers to play client roles very, very convincingly, including being as confused and emotional as you like. And that's the best way to do it. The experiential learning approach is the one that works for this type of activity, and boy, they can be difficult to deal with for the students, and the students have to rise to the challenge.
So teaching the actor to not understand as a simulation of what was being described as the problem.
Oh, indeed. That should be part of it, once students are reaching a higher level.
Yeah, good. I'm out of time for my part of the presentation, so thank you. I hope you will all give some thought to how these 26 effectiveness factors could be useful to you in your teaching and in the future of admissions in American law schools. Thanks.
And before everybody heads out, we'd like to take this moment to open it up to all of you. If you have other questions for any of the panelists or any additional topics that you want to discuss, we've got about 15 minutes left since we're backed up right next to the next session. Does anyone have any questions that they'd like to put to any of our panelists? And there's a mic in the center, or feel free to just verbalize.
I'm Susan Carl from American University, Washington College of Law, and I so agree with the idea that our admissions policies, as well as what we're trying to do in law school, should really focus on all of these competencies, and that the LSAT is a very counterproductive in many ways tool to use. But I'm wondering if these tests really will work, whether we wouldn't end up with a whole sort of gaming industry of trying to, train students to come across well. And I'm just, are you talking about this in the level of theory, or do you think this could really be effective?
So, really good question. Marge and Shelley, first of all, one of the next steps that we have to take, and we can take it even as we begin to implement the tests, is to examine the question of coachability. Here's the problem with measuring coachability. There are two sets of research, two sets of studies on coachability of admissions tests. One set has been funded by the people who build, administer, and sell the tests. And they inevitably show that these tests are not coachable. The other is a set of studies done by people like Kaplan and Princeton and the people who sell, the people who coach. And their studies all show that these tests are coachable. So finding the right people to test for coachability is a challenge. Beyond that, Shelley in particular thinks that it's likely that these would be hard to coach because in general, there's no right answer. Rather, the answers are ranked. So, a sample question is that you're at work and you discover that a friend of yours to whom you've been a mentor has done something dishonest. What do you do? And there are a series of things that you could do. The point of this is to test your judgment in an ethical crisis. Well, it's not that there's one right answer. There are a variety of answers, some of which are better than others, and some of which indicate one kind of decisiveness and others something else. So the complexity of the tests makes it less likely that they would be highly coachable, but yes, it is a concern.
Lyle Baker, I'm at Suffolk Law School, but a question about the instrument. Is this a self-assessment where someone says, I think I do this way, or is this somehow objective? Because there's apparently, people are rating themselves, like Wake Wobegon, we're all above average. Can you comment about that?
The test that Marge and Shelley have developed is an objective test. I think the 26 effectiveness factors has some value for self-assessment. So for example, I give it to my students at the beginning of the semester and I say, these are the kinds of skills that you want to develop to be an effective lawyer. And at that level, I'm expecting them to both self-assess and think about how they can improve on those skills. But if we're talking about using it as an admissions test, that's why I said it would have been enough if they just developed the factors, but they then went on to scale them, and they then went on to develop a series of tests, a battery of tests, many of which have been around a long time. Some of the situational judgment tests that they include among their material were developed in the 1950s and 60s and continue to be used and continue to be tested. Others they developed themselves. But no, none of it is self-assessment if you're talking about the use as an admissions tool.
Sophie Sparrow from University of New Hampshire. So I actually have two questions. Is the Marjorie Schultz-Schedenzetic instrument available, and are schools using it? And does U.S. News and World Report use it?
Well, of course, U.S. News and World Report looks at the LSAT. We are trying to make it available on an experimental basis. There are a few schools who are interested in using it. We need more research money to develop it as a test that can be administered on a continuing basis. At this point, we could administer it once, but in the process, we would burn it. And so we need more research money. We've been looking. We have not succeeded in finding it. If anyone here, particularly somebody who's still got another 20 or 30 years to go in your career, says to yourself, gosh, this is what I would really like to do. Come talk to me. You should be part of the team, and you should be helping us look for that research money and extending this research. But at this point, no, it's not that we can hand it over to you and you can use it,
Right.
to my regret.
Thank you. My second question is for Alli and Heather, which is, to what extent are the things that you notice as being successful in what you're studying, are they incorporating or not duplicating, but reflective of the 26 factors?
Yeah, I think there's a lot of overlap. So it's kind of validating the research that's been done. If you look at, I showed a couple competency models that law firms use, and you'll see a lot of the same sort of behaviors and skills that have already been identified. So I think it's nice. It's a sort of a natural corroboration that what people see in practice is matching the research that's been done.
And certainly, I see a lot of overlap. I mean, we started with this, and Marjorie Schultz was one of the researchers who reviewed our survey before it went out. So we certainly do see that. What we hope our survey brings to it is some better understanding of how are things different, based, again, like practice settings, size of organization, region, whatever, to give individual schools some additional information to work with. But certainly, there's a lot of overlap, and like I said, this was a major thing that we looked at when developing the survey.
I'm sorry, I want to ask one other question. The question of whether this is educable or not, is it trait, state? Is it a situation if you're selecting for it in admissions, that's what you got is what you got, or is it a case where the outcomes can be influenced by the educational process, which is why we're all here?
Yeah, really good question. You're right, there are two kinds of coaching. One is, can we teach people to be better at some of these skills, and as a result they'll do better on the test, but in fact it's because they're better at these skills? Well, that's great. That's what we sometimes call education, right? We're all for that. On the other hand, there's the concern that people will learn how to game the test. There's a third kind of coaching. There's the kind of coaching in which people become familiar with the test and how it's administered, and as a result they do better. The concern with that is, does that reproduce income and racial inequality because of who has access to that kind of coaching? And then finally, there's potentially coaching to sort of game the test. That's the one that we're most concerned about in theory. But again, it's the area where Shelley, as the scientist, says that he doesn't think this is likely to be a test that could be coached.